Good afternoon. My name is Ronaldo Hilton, the chairperson designated from the New York City Loft Board. Welcome to our April 19, 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the timely conversion of dwelling buildings from commercial and manufacturing spaces to safe, rent-stabilized residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. We first turn to a vote of the minutes of the March 15th public meeting. Are there any corrections or comments to these minutes?
Yes. I found on page 4, case 11, Caitlin Wall. Wait, sorry,
Yeah.
the summary of my concerns in that case was kind of truncated in a way that doesn't really cover the key points.
Okay.
So I wrote out a short, relatively short, not terribly short, probably short and a little.
You want to read it?
Yeah. If you recall, this is the case where
Yes.
we found that the transaction between the estate and the landlord did not constitute a sale of rights under 286.12. So I won't bother to read you what's there now.
So,
Do you want to
no,
keep
we
what's
have
there?
to,
No.
yeah, we have to. So you're going to, if you want us to modify this, don't we have to kind of get on the record what you want to say?
Sure.
Yeah,
Sure.
we have time.
So Mr. Delaney stated that he agrees with the recommendation of the oath hearing officer insofar as it finds that the transaction between the owner and the estate of Mr. Hetherington did not constitute a sale of rights or fixtures to the unit. He pointed out that the owner rented the unit to Ms. Wall before the negotiations with the Hetherington estate were even concluded, and that the evidence presented by the owner seemed to involve discussion of the sale of a few items in the unit. He stated that he intended to vote no on the case because of the board's decision to request further proof from Ms. Wall regarding the question whether she used the unit as a primary residence before determining that she was the protected occupant, despite the fact that it appears clear that this is where she lived. He took issue with the reasoning in the proposed order that since she had applied for coverage after the initial one-year lease that the landlord gave her expired, she was not automatically the primacy of the unit. He pointed out that many tenants who were found to be protected occupants over the years under the loft law had leases that had expired many years before coverage applications. Sound familiar?
Yeah, does anyone? No, it's fine. It sounds familiar.
So,
Is that a proposed new language to replace?
well, I have a couple copies that.
Yeah, could you just pass it?
Yeah. I don't have enough for everybody.
Oh, okay.
I didn't think there would be that much interest.
Could you just let me know where in the minutes are you trying to?
This is bottom of page 4.
On page 4. I'm sorry. Okay, so you replace that paragraph with this, right?
Yep. Thank you.
So we agreed to add this to the minutes? I didn't hear what was.
You have this one.
No.
Could you let Mr. Harris have a copy of this?
Go ahead.
He's got it.
Oh, you got it. Did you read it? That's what we just read. He wants to replace that
Do I need
paragraph.
to read it the second time?
No, if you're comfortable with it, I just don't want to.
Savor every word.
Keep it for later.
I move that we insert this in the minutes.
I'm fine. That's the motion, right?
Yes.
Is there a second?
Yeah, it was second.
Rivera.
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shepherd?
Yes.
Chairperson Henson?
Yes.
6 in favor, 1 absent.
Are there any additional changes or any comments on the minutes? Is there a motion then to accept the minutes with the changes that was just voted on? Yes, Mr. Carver. Mr. Carver. Is there a second? Mr. Second. Okay, Mr. Rivera.
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Hernandez?
Yep.
Mr. Delaney?
Yes.
Mr. Shepherd?
Yes.
Chairperson Henson?
Yes.
6 in favor, 1 absent.
Thank you, Mr. Rivera. Ms. Elaine Balsam now will give her executive director's report.
So, Mr. Hernandez, this lady may want. And of course, it's not working.
Is the power off?
I just closed it. I didn't.
Probably shuts off.
Is there power? Is it working?
Yeah. Yes. So, the lights on.
Yes,
Yeah, it needs
it's
to
coming.
Has to warm up, yeah. All right, so as it's warming up, as of yesterday, the Loft Board and the Department of Buildings went live on the New York City Open Records portal. So we wanted to get the word out that that had happened and to encourage you to use the portal. It is actually a legal requirement, but I think it's a great thing. So unfortunately, we don't have internet access here, otherwise I would just go to the internet and show you how it works, but we don't. So the URL is www.newyorkcity.gov/open-records. And when you enter that, you get this welcome screen. And then you have 2 choices. You can either check requests that are pending, or you can request a record. So if you want to request a record, you click where the arrow is on the lower right. And this is the next screen that pops up. For agency, the first one, the category is optional. If you want it, you can use it, but otherwise, go to agency, scroll down to Loft Board. And then as you scroll down the screen after you enter Loft Board, you put in a title for the request. So let's say, latest narrative statement or something like that. Whatever you want to title it, that's up to you. And then actually what the request is. So a little blurb in the box, about 2/3 of the way down the screen as to what the request is. You can also upload a document if you want to that gives more information that will also go along with the request to us. You continue scrolling down that screen and fill in your personal information so that we can respond to the request. Alternate contact information if you want, but you don't have to. And then on the very bottom, it says submit request. And that will be sent by the portal to New York City Loft Board FOIL request mailbox that was set up to service the portal. So we will get an email that says, hey, there's a request in the inbox, and the portal itself tracks everything that happens. We send the acknowledgement, we tell the portal we did that, we deny the request, we grant the request, etc. The cool thing about it, though, is that you can look at other people's requests. And the whole purpose of the portal is to avoid duplication in FOIL requests. So if the information is public, which most of it is, I forget what the distinction is, where we can satisfy the request but mark it private, or satisfy the request and mark it public, and I don't remember exactly what the distinction was, but assuming that we satisfy the request and mark it public, anybody can see that information. It gets uploaded to the portal, whatever documents we provided get uploaded to the portal, and you can submit a search where it says check for similar records. You can search for those records, so the records may already be out there without you having to actually make another request. So it's really kind of cool, actually. So you can enter whatever search terms you want, and then it'll come up, it comes up in chronological order. And I just did one, kind of an old one, because other agencies had been on longer than us. We're one of the last agencies to be onboarded. So this is just an old one from the Environmental Control Board. And you can see, well, let me go back. So you scroll down in terms of the request, you find something that looks interesting, you click into the FOIL number on it, and then this screen comes up. And where it says responses, nothing will be there. You have to click on the little question mark. So in this particular request, there was an acknowledgement that was sent, there's a file that was uploaded, and then the request was closed. And this one, I think, was about asbestos violations related to Maimonides Medical Center. So if you click into the file one, it actually shows all of the records that were supplied to whoever the requester was about asbestos violations for Maimonides Medical Center. Obviously, that doesn't relate to Loftport, but I just use that as an example because we don't have any yet. So that's how it works. I would urge you to give it a shot and use it if you have a FOIL request, and to see what else is out there, because there's going to be a lot of information out there, and I think it can be very helpful to everybody. So that's that one for Loftport.
So, just to, this is the first I've heard of this, and it sounds very helpful. This is an alternative way to file a FOIL request.
Yeah, actually, I think eventually the old-fashioned ways will be phased out and everything. The idea is to get everything to go through open FOIL, so that as many records as possible are out there on the web for everybody to look at. That's the rationale behind having the portal.
Mm-hmm.
So, yeah.
Okay, not to jump ahead in today's adventure, but should we make some mention of this in chapter 1 where we talk about FOIL?
In the rules?
Yeah.
Can you bring that up again when we get there?
Sure.
Okay. Maybe we should, but.
Well, particularly if it's the old ways that are currently set out or headed toward
Right.
the repository.
The break.
Yeah.
Okay.
Is there a charge per page like there used to be for a copy?
Well, if the documents are being given electronically, then no. So, and theoretically, if you're getting them through the portal, you will be getting them electronically. I guess there could be records that are so large that we would need to provide them on some other kind of medium, but I don't necessarily see the Loftport having that issue.
So just to pursue this a bit further, if a tenant or an owner were to file a request for all applicable records related to a given IMD address, that would go through this, come to you, or go somewhere.
It goes to an inbox.
It goes to an
special
inbox.
separate FOIL inbox that the Loftport set.
That the law court staff then will visit periodically,
I would assume several times a day.
several times a
We
day.
get a lot of FOIL requests.
Really?
Yeah.
How much do we get?
You know, compared to when I worked at ECB, I would say, you know, we get, I don't know, 3 to 4 a day probably.
So that'd be like 15, 20 a week.
Yeah, but it's
That's huge. I mean,
a
Yeah.
lot.
No,
For a
I-
real agency, that's a lot of
I-
FOIL requests.
I had no idea, that many people care. So I make a general request about a building.
Right.
And there's a lot of documents,
Right.
which are all in those crazy files that were set up years ago, the 1, the 2, the 3, and the 4. So then somebody has to go scan all that?
Well, it depends. I mean, it could be that we would call you and say, do you want everything? And if the answer is yes, then yes, they're entitled to it, and yes, somebody would have to scan. But the rest of FOIL still actually applies. So if it's going to take more than 2 hours, we could bill for that time for the scanning. So it would be whatever the lowest pay rate is for the employee that can do that work, we could bill for those hours. So we would give an estimate, well, this building's been in our jurisdiction for 35 years. So we have a lot of records, and if you want all these records, we estimate that it's going to take our college aide 10 hours to do this. The first 2 hours are free. You would have to pay for 8 hours worth of scanning if you want to do that. Which is no different than actually photocopying. I mean, it's really a similar process, except that it's stored electronically, and if we upload it, it'll be there for everybody else to see, which I think is the best thing.
And the notion is then, so, yeah, you have a building with a lot of tenants, and one tenant makes a FOIL request, and gobs of information are uploaded and scanned, and then the repository is on this site,
Correct.
somewhere presumably in the New York City cloud.
Right. Right.
So is this going to make more work for you or less work?
It's probably about the same amount of work. Yeah, I think it's the same amount of work. It's just different in terms of the path that's filed.
Or perhaps less work eventually.
Well, if we're getting duplicate FOIL requests
Right.
now, which we do sometimes, it may work, it may.
If you get
make less
20
work.
requests
For the same
for the
document.
same building.
With less paper.
Oh, I hope it's. One thing that's interesting is that a lot of people actually aren't sure what they want, so they actually come in and look at records, which is still an option. So, we may still ask people to come in and look at records, depending on what the request is. So, but that's the open records.
All right.
All right, Mr. Barowitz, you had asked last month about the backlogs. So, Martha put together a chart of the backlog. So there's a total of 50 cases that were returned from O. 15 of them were masters and 35 are summaries. So I don't know if anybody has any questions about that.
Actually, yeah, so the year, that's not the year that it came back up, right?
It is.
Oh, it is?
No, that's the year it was filed.
That's the notice filed?
Yeah, that's the code.
Sorry,
All right.
take it back.
That's a lot better.
Take it back.
So this includes our backlog of cases other than removal cases.
Right.
Yes. Okay, in terms of registrations, we still have 18 buildings that have failed to register for fiscal year 2018. Staff is preparing to send out the registration invoices for fiscal year 2019, and those are going to go out on or about June 8th of 2018. Our revenue for March, unofficial revenue was $34,226 because we had somebody pay a registration fee. In terms of enforcement, staff mailed out 37 administrative determinations based on a failure to file the monthly reports. The cure date for those is May 14th. One owner already paid the fine. The HPD inspector issued one no-heat violation in March. He is continuing to do the inspections for signage. So far, he's visited 72 buildings, although he wasn't able to get into all of them. And he's issued 4 violations. It's actually gone very well. A lot of signs are posted, so I'm very happy to hear that. Litigation, the owner of 401 White, 62 South 6th Street, commenced an Article 78 proceeding challenging the Loft Board's determination that one of the units was not in a basement because the C of O indicated that the unit is on the ground floor. So I think we all remember that case. I think it was in December.
What's the name of it?
That's
Saladino?
Saladino, yeah,
Okay.
Saladino. And also on April 10th, in parallel decisions, the Supreme Court in New York County found that the Loft Board acted irrationally when it refused to allow applicants to withdraw an application and required the applicants to litigate. In the same decision, and the Loft Board did that because the settlement would have allowed for illegal occupancy. In the same decision, the court also said that she did not find irrational the law court's rejection of the settlement, that it considered it appropriate. So, that's it.
Thank you, Mr. Walton.
Couple of questions. The 18 buildings that didn't register for the prior year,
Yeah.
have those all been subject of failure to register?
Yes.
Proceedings? All
Yes.
18, okay.
And they will face higher fines this year because the penalty schedule goes up for the number of years that they don't register.
Let me ask you a very strange question. Are these fines paid in a reasonable amount of time?
Depends on what you define as reasonable, but they get paid eventually.
They do.
For the most part, they get paid, yeah. Largely just the owners want to do work, some kind of work, not necessarily full compliance work.
Okay, also, I'd like to request a copy of the papers in 141Y in this salary.
You want a copy of the papers?
Yes, please.
Sure.
And as we discussed earlier, I've requested a copy of the court decision in the second case you reported on. And I've made the request that in the future, when court decisions come down, they be circulated to board members as one board decision. Thank you.
If I could also get a copy of those papers.
Yeah, sure.
Can we just send this to them?
Yeah, I can send it to everyone.
And I just wonder if I could just bring up another topic, just about the process of our meeting. So now that we're spending an hour in session privately to talk about cases, just wondering if we really continue to need the reading of the cases here in this meeting. My feeling is that we have a lot of pressing business to attend to, especially with rulemaking. And I'm just wondering if that's really a good use of our time to have the cases represented in public after we've spent an hour on this.
It's a good use of our time. That's my opinion.
I don't recall why we were doing it. I honestly don't recall why we wanted a public presentation.
I think it's a good use of the public's time.
Yeah, well, that's right.
Well, of course, this is our meeting. It just so happens to be held here in public, but it's not really for the public. It's our meeting, I guess. So why do we need to have it twice?
Well, but it's for the public because it's recorded and it's possible to go into it, you know.
I mean, the meeting is subject to the open
That's
meetings
right.
law,
Yeah.
so.
that's why.
It's an open meeting, but it's our meeting. There's no commentary. They're just watching.
We've discussed this already, and this is what the board decided to do on how to present the cases.
Okay, so I'm just wondering if it's worthwhile to reconsider that decision.
That's the board members.
I'm all about finding ways to streamline the process.
Well, in which case the public here has no knowledge of what these cases are. If we just simply decide them with no review.
I agree. Does anyone else have any comments on it?
I think these cases, are they now posted online, or will they be with the rule change?
It's a rule change.
The rule change will be posted.
I mean, after the decision is rendered, they're all posted online on the city admin site. But
I meant
prior to
I
that,
meant
yeah.
One thing just to keep in mind is I think the point is that if we can find ways of streamlining the process so that we can move along, I think that's, because we do get a lot to review and then we'll also go into the rules. Whatever we can do, I mean, if the rest of the boards think that was needed, but we should continue to look at that streamlining
I
process.
understand the rulemaking piece is a temporary insertion here in our process, so I hear you. We should always find ways to streamline anything we do, but I feel strongly about presenting, letting the public understand what the cases are being reported on, what they're about. And so that's just my feeling. If anyone else has any take on that.
Well, I agree, and then, I think streamlining is always a good idea, but we hardly spend more than 2 hours here at the public meeting. It's not a whole lot of time. We could pay us for it.
All right.
Yeah, I just certainly want to go on record as thinking this is time well spent.
Is this something to vote on here or no? Or we just, no, right? All right, so we'll move along. We're going to discuss the redaction of consideration in sales forms and agreements.
So the board had asked that we put this on the agenda for this month, so we did.
It was my request, so I'll be happy to restate, if it doesn't appear to be a waste of time, the reason I made this request. I am, particularly in this era where we're finding many cases that involve issues regarding the validity of a 286-12 sale, owners who file 286-12 sales decades after the document was executed, one particular building where it appeared that the owner was attempting to gin up what were really refunds of security deposits and trying to turn them into 286-12 sales. That I think the board's allowing owners to submit documents that purport to be 286-12 sales with the dollar amounts redacted is a mistake. And I intend not to vote for any case that includes that kind of redaction in the future. Our rules say that they have the option to do so, and I think that rule should be changed. I think it should be mandatory that the actual document be filed as it was executed.
So one of the questions that arose last time was whether or not, if we had the amount of consideration in our records, so that we required people to file the sales agreement showing the amount of consideration, which is not necessarily always monetary, but anyway, whether or not, if we received a FOIL request, could we redact that information? And I did do research on that issue, and the answer is no, we could not. There is no FOIL exemption, and I did go to the law department just to double check. It's not just my opinion. There is no FOIL exemption that would cover redacting that amount if we were going to release the record. Obviously, if we never get the amount of money, then we can release what we have. We don't actually have a rule that allows them to redact. Our rules are silent.
It's the form itself.
The form itself has it, and I think if we were going, even if we took it off the form, we would have to have a rule that says the amount of consideration must be included.
Right. And I will, when we get to the proper time and place, I will propose such a rule.
So, and the other issue that came up, has come up a couple of times, was the question of whether or not the person who was selling their rights had to be in occupancy. So if we were going to do something with this rule, I would ask that the board also consider requiring that whoever is selling, absent obviously death, that whoever is selling actually be in residence at the time of the sale, because that has been sort of an open, I don't know that it's an open issue. We say that they have to be there at the time of the sale, but there have been issues surrounding that as well. So if the board wants a rule, wants to change this rule to make those changes, I'm more than happy to draft something. But you gotta let me know.
I'm not understanding the problem So I don't know how this would solve it. So what's the problem exactly?
Well, where did the redactions come from, you know?
I don't know when it started, but the current form that we have says, the sales record form that we have, says attach a sales agreement, you can redact the amount of the money,
So
basically.
who redacts it? Who
The-
does it?
The owner,
The owner or the lawyer? The owner or something?
yes. It's the owners that file the documents with us, so it's the, I'm assuming it's the owners that
I'm
do
assuming
the
it- okay, I
redactions.
just wanted to make sure.
Why that is on the form, I don't know the history of it, but that's how
But
it
you
exists.
simply get it, you don't know exactly who redacted it. You just assume that it's the lawyer,
Whoever's
the owner. or
filed
something.
it, yeah.
Well, I mean, I certainly agree with Chuck on this.
I mean, the issue I
I mean, it's
think,
very disconcerting to read this stuff and then see these blackout areas. You know, you think we're in some other kind of situation, in another world.
Is that information that is subject to FOIL?
yes,
And then that information, is that information something that would be redacted on a FOIL request?
no, we can't redact it, I
Can't.
researched that,
Okay.
cannot
Cannot
redact
be
it.
redacted.
So,
If we receive it redacted, then obviously we give out the document that we have. But if we require people to give it to us unredacted, we will have to disclose the entire document if somebody requests it.
and do we have the power to do that?
To do what?
To inform the set of rights that nothing can be redacted. We have the power to tell the landlord or the attorney for landlord who's ever doing it to not keep redacted these.
Oh, well, our rule would basically say you can't redact it, right? That's what we're thinking about.
Well, that's right.
So, and then if the information is there, Helene is saying, by FOIL law, we cannot redact if somebody
I
requests it.
understand.
So, I mean, I don't see, I don't see why we should oppose that. I mean, are you gonna make some sort of a suggestion? Are you asking if you should?
I mean, if the board wants me to
approve?
draft something, I will be more than happy to draft it.
Well, I had asked, and no one has yet answered what the problem is.
Well, I think you articulated.
Yeah, I'll be happy to repeat my summary or attempt to.
I didn't understand what you were driving at. Is there a possibility of fraud? I mean, I don't
Yes.
understand. Okay, so if
We had a case last month where the owner said, this tenant's not covered because I have a 286-12 sale from somebody else. The somebody else provided a statement saying that she didn't sell rights, she didn't know she was selling rights. And I think she even had it notarized or something, if I recall correctly.
She had an affidavit, she filed an affidavit.
She filed an affidavit
Sold it, right.
taking issue with the owner's characterization of whatever transaction they had as being a 286-12 sale of rights. We've had owners go back to find tenants. I don't have all the cases at hand, but we've had numerous issues where the owner went back and tried to get a hold of somebody to ask them to sign a statement affirming that what they did when they took that money was a 286-12 sale. And in this era where instead of whether or not a unit or a building is an IMD unit or an IMD building is such a hotly contested issue, this is a way of preventing people who perhaps should be covered from being protected.
I'm sorry, I'm not following. I thought that the issue is whether this document, the issue is not whether the document is required, the issue is whether the owners can redact the dollar amounts in the document. So therefore, what you're talking about sounds like a situation, if my recollection, the question where the document exists or it doesn't exist, or whether it applies or it doesn't apply, not a question of a dispute in which there's a document that everyone agrees to, but there's a dispute about the dollar amount, and we can't determine it because it was the dollar amount was redacted.
The redaction compounds the confusion over some of these transactions and whether or not they actually rise to the level of 28612 sales. And again, kind of the poster child for this issue is Sutton Place, Sutton Street?
99 Sutton.
99 Sutton, where the owner came up with 32 documents that he alleged to be sales of rights that seemed to have, for the most part, been 28612 was inserted into, I acknowledge I got my security deposit back. So, and at the same time, if somebody says, no, we had the case, I think a couple months ago where somebody said, no, wasn't a sale of rights, and I would have never sold my rights for that dollar amount, and the dollar amount was redacted. There are a number of things wrong with the 28612 sales process. That I grant you. One of the big ones is that there's no requirement to file it until it behooves the owner to do so. So there have been dozens and dozens of cases where the owner rents to a new tenant and says, oh, well, this unit's covered under the Loft law. 2 years later, the lease runs out, the landlord increases the rent significantly, the tenant files for coverage. After having their attorney do due diligence, there's nothing at the Loft board, and then lo and behold, like a get out of jail free card, the landlord produces a 28612 sale from 20 years ago.
So, I'm sorry. This originates with the idea that there's a form by the Loft board that specifies to the owner that they must provide this document.
Yes. There's a form that the owners file, which is the Loft board form. And to that, they have to attach documentation supporting the sale. So the form itself does not actually ask for the amount of consideration.
But their failure to provide this package to the board in a timely fashion is.
They're subject to a fine if they don't. They're supposed to file it within 30 days of the sale, and if they don't file it within 30 days of the sale, then they're subject to a fine. And we have just started enforcing that. We've issued violations recently, just this year, on these late sales.
I guess it sounds like, as you said, Chuck, it sounds like there are many issues involved in this process.
Yeah.
So, but in terms of this specific topic about whether we're going to require the dollar amounts to be specified or not, I'm not sure what the impact. I understand why. I understand that the owners want to keep it quiet because they want to be able to maximize whatever market competition they have between the tenants, and they don't want the word to get out for whatever reason. I understand that there's an incentive for sort of Loft board in general that we want amicable proceedings to occur between parties as we get towards resolution. I'm not sure whether the desire to get the dollar figures on our part is worth overcoming those other issues. And I'm not saying that is not possible. I'm just saying I'm not following what our specific desire is.
Can I interject?
Yeah.
So if there was a question about whether or not something was a legitimate sale, and you were looking at a sales agreement that said somebody was paid $25,000, that would be one thing. If you looked at a sales agreement that said somebody was paid $1,872.56, that might lead you to believe that it was not actually a sale, it was a refund of a security deposit. Whereas the $25,000, I guess there are apartments that go for that kind of money where they could have a $25,000 security deposit, but unlikely. So I think that's the rationale behind it, and there was the issue in the original 99 Sutton case, which is still pending, but as to whether or not some of these were alleged sales were refunds of security deposits. And because the amounts were redacted out, it was a lot harder to tell. So just to give you an example.
Yeah, but if there were ever a question of fact that required that number, I suppose the burden would be on someone to actually find that number. The other thing is, are tenants typically represented by attorneys in these transactions? I mean,
Some are, some are not.
if they are, then the whole question of fraud is kind of out the window, right? I mean, and the,
And if they're not,
Are you suggesting that they can redact the number if there's if the tenant is represented by an attorney, but they shouldn't redact the number if the tenant doesn't have an attorney?
not necessarily, but if the problem is that, someone is pulling a fast one over the tenant, and for that reason, all these should be unredacted, then I would just say, well, if tenants have attorneys, that's not necessarily the case. So I think it's a bad idea I think allowing redaction is a good idea. I think we should not be interfering with the desires of private parties to make deals.
But let's,
But you know, if you outrightly sell an apartment, it goes into the public record in the city of New York. Why is this a whole lot different?
A buyout is not a public record.
but it's a fair analogy. The expectation of privacy.
Quite high, especially on the tenant side. I don't know that they want the world knowing their business.
well, is the tenant gone from this process now that they filed?
Well, the tenant takes the buyout and leaves.
Right, so
I mean,
it's not like we can say we get that information from the tenant's copy of the transaction with the person who bought up and it's no longer part of this. It's a one-way communication, correct?
No. Well,
This
No,
piece?
the documents are signed by both.
No.
Supposed to be
What's being
signed by the
submitted to
tenants.
us is being submitted by one party.
Yes.
So there is no cross verification. We can say it's right?
I don't know if this is appropriate to make a motion, but it sounds like if a tenant is not represented by an attorney, then the dollar amount should not be redacted.
I mean, in that sense. But,
it's a partial solution. I mean, it's better than the alternative.
That presumes that attorneys always, we have a case on the docket today where one of the parties is claiming that their former attorneys didn't do things right. Attorneys don't always do things correctly. Every now and then, maybe there's an attorney who's guilty of fraudulent behavior.
shop.
Shouldn't allow national news to contaminate our property.
I don't think you have to go nationally necessarily, but obviously.
Doesn't happen in New York City.
So is the notion of trying to prevent the designation of a unit as being an IMD or an IMD with a protected occupant becomes something that's fought over more aggressively and more stridently? It seems to me that in our interest, I don't care if it has an upward or downward effect on the value of what the landlord and tenant are willing to negotiate. Now, the purpose of here is to preserve a special kind of affordable housing, not to make a market where scarcity could drive prices through the roof.
No, Chuck, you're the one who thinks that if the number is too low, then it's not a real sale.
No, they didn't say that. I think maybe your fear is that if suddenly we start seeing figures and other law tenants say, gee, they got $25,000 for this, I'm gonna ask for 35. And somebody said, well, I got 35 for this, I'm gonna up it up. Well, but that's the way the market works, right? So what's the big deal? It's the way it works in the general market, of sale of apartments. A lot of apartments are put on the thing, and sometimes they're overbid. It's the way it works. So why should it work for quote loft tenants?
No, leases and lease buyouts are not public records.
And that may be fine in the context of the rent-stabilized world, but here we're dealing with these units that are in transition, and
I'm always hearing about how this world is so unlike the rest of the world. It just isn't. I mean, in a court case,
That's what Mr. Brock.
if you're in court, you can settle a case. No, in the real world, lease buyouts are redacted.
So, we need to put this to, correct? A motion. I think Mr. Delaney.
yeah, I will move to ask the executive director to draft language for our consideration that would require that sales of rights to be accepted by the Loft Board include documentation regarding the sale without any redaction.
I just want to clarify that before we make it. So
Sure.
any redaction is, I mean, we were talking just about monies just now, but is there anything else on this, on that information that can be redacted except the monies?
There's nothing else that's
Nothing else,
protected
okay.
now.
Well, just a second, you've got SS numbers that could be on there.
No, well, anything that's personal information, we would never give out anyway, because we're not allowed by law to give out that information.
And also, you realize that, I mean, these deals may wind up not having any dollar amounts in it, because it may be for nothing, but.
Okay, but can we just be more specific on that?
Sure.
Okay.
No redact.
Oh, no.
If it's X amount of dollars, 3 chickens, and 2 years of free rent, nothing gets redacted.
Is there a second? Is, Mr. Rivera?
Mr. Carlos,
No.
Mr. Bauer,
Yes.
Mr. Fernandez. Mr. Hernandez.
I need to abstain for now, I'm still debating inside.
Mr. Delaney,
Yes.
Mr. Chacton,
Yes.
Chairperson Johnson.
Yes. I think he said for now, so you can go right back to that.
No, I was abstaining. Oh,
I just abstain.
so just to be clear, you're just drafting, and we will vote on it, right?
Yes, oh, yes.
Okay.
Yeah.
Yes.
Huh?
Yes.
Yes, okay. 5 yes, 1 no, and 1 absent.
Okay, motion is sustained. Thank you, Mr. Rivera. All right, we now turn to cases. Consideration calendar. We start with the appeals and reconsideration calendar. There are 2 cases on the calendar. The first one is, how do you say that? Lad Limited Partnership at 73-77 3rd Street in Brooklyn. Docket number R0355. Mr. Bobby, please present us.
Thank you. Owner applicant seeks reconsideration of Loft Board Order Number 4651, in which the board imposed a fine of $5,000 against owner for failing to register the building. In a stipulation dated July 10, 2015, settling a coverage case, owner agreed to register the building with the Loft Board within 30 days. Owner failed to register. On October 20th, 2016, more than a year later, the board issued an order in the coverage case directing owner to register the building and pay the registration fees within 30 days. If owner failed to comply, the board directed its staff to issue an IMD number and collect the fees due. On October 28, 2016, staff mailed a coverage order to owner at an address in Staten Island. Again, owner failed to register. On November 30th, 2016, staff issued an IMD number for the building. Staff also mailed a registration invoice to owner dated November 30th, 2016, and mailed it to its Staten Island address, indicating that the building registration had not been filed. Once again, owner failed to register. As owner failed to comply with the stipulation, the coverage order, and the invoice, staff sought an order finding owner in violation of the MDL and the Loft Board's rules for failing to register the building and for failing to pay the registration fees. As owner failed to respond to the notices sent to the Staten Island address, staff mailed a notice to the entity listed with the Secretary of State as owner's registered agent. Owner failed to answer and again failed to register. On March 16, 2017, the board issued order number 4651, which found owner in violation of the MDL and the Loft Board's rules for failing to register and imposed a fine of $5,000. Owner now argues that the Loft Board denied a due process because it failed to serve owner or its attorney with the notice. Staff disagrees. Prior to issuing the notice, staff made several attempts to contact owner at its Staten Island address. After receiving no response or registration application, staff served the notice on owner by mailing the notice to owner's registered agent, an entity designated by owner to accept service on its behalf. Owner also argues that the Loft Board's imposition of a fine in Order 4651 is an erroneous determination based upon a ground not argued by the parties. Staff disagrees. Owner has never advanced any arguments whatsoever against coverage of the building. Instead, owners failed to comply with what it agreed to do and failed to comply with the coverage order, invoice, and notice. The Loft Board's rules are clear. The failure to timely pay registration fees may result in the imposition of civil penalties. The imposition of the fine in Order 4651 is a logical and reasonable consequence of owner's inactions. Finally, owner argues that it could not have reasonably anticipated that its prior counsel would not register the building. Again, staff disagrees. And an attorney acts on behalf of its client, but the quality of the representation does not relieve its client of its responsibilities or obligations under the law. Even if owner's prior counsel was dilatory, that is not a reason to vacate the fine imposed by Order 4651. Staff recommends that the board deny owner's reconsideration application.
Thank you, Mr. Bobbitt. Does anyone have any comments or questions about this case? No questions or comments?
We did modify the language in the order.
Yes, Mr. Bobbitt, could you just please read the corrected language by the last paragraph of the order?
Even if owner's prior counsel was dilatory, that is not a reason to vacate the fine imposed by Order number 4651.
Right, so we're making a very ministerial type of change to the last sentence on before the conclusion. Thank you. With those edits to the proposed order, do we have a motion to accept this? Mr. Lillian. Is second? Mr. Shack. Do we, please, Mr. Lillian.
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shacker?
Yes.
Chairperson Hudson?
Yes.
6 in favor and 1 absent.
Thank you. The second case on the appeal and consideration calendar is Trekman Estate Inc. and Celia Gong and Man Ken Gong at 241 Center Street in Manhattan. Docket numbers are R0360 and R0361. Mr. Clark will present this case.
Thank you, Chairperson Hilton, board members. On October 19, 2017, the Loft Board issued order number 4701, which rejected a proposed settlement of a coverage application as against public policy. Both sides filed for reconsideration. The proposed order before you today consolidates the reconsideration applications. Each side alleged denial of due process an error of law as the basis for the reconsideration. In the stipulation at issue here, the tenants withdrew their application with prejudice, but intended to continue to occupy their units for residential purposes. The spaces do not have a residential certificate of occupancy. MDL Section 301 prohibits residential use of a space until the issuance of a residential certificate of occupancy. The withdrawal renders the residential occupancy illegal. In their reconsideration, tenants argue the Loft Board could accept the withdrawal of the claim and disclaim the remaining terms of the stipulation. However, since 2012, the Loft Board has exercised its authority to reject proposed settlements where tenants withdraw their Article 7C claims but continue to illegally occupy their units. The Loft Board has the authority to do so pursuant to Section 1-06J5 of the Loft Board rules. Tenants and owner further argue the Loft Board is compelling them to litigate. This is simply untrue. The parties are free to reach a settlement that does not contravene the law or run afoul of the Loft law, such as registering the building or living in a place outside the building until the issuance of a residential certificate of occupancy. Owner argues that the Loft Board made an error of law because the zoning resolution prohibits the creation of new dwelling units in the M1 5B zoning district. However, tenants filed for coverage pursuant to MDL Section 281.5, which explicitly exempts the use restrictions in zoning districts from the coverage determinations. Finally, owner argues that even if new dwellings were permitted, the tenants are not qualified to occupy the space because they are not certified artists. However, if tenants are granted coverage, tenants are entitled to occupancy pursuant to the Loft law and not the zoning resolution. The other arguments presented are unavailing. Staff recommends the board deny the reconsideration applications.
Thank you, Mr. Clark. Does anyone have any comments or questions about this?
I have a question for clarification. If Mr. Clark could just restate the section that gives the Loft Board the right to object.
That is Section 1-06J5 of the Loft Board rules.
Thank you. Any other comments, questions from Mr. Clark? Okay, very good. Does anyone have a motion to accept this case? Thank you, Mr. Shah. Do we have a second? Mr. Hernandez. Mr. Rivera.
Mr. Carver.
Yes.
Mr. Barber.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shafton.
Yes.
Chairperson Hinton.
Yes.
6 in favor, 1 absent.
Thank you, Mr. Rivera. So there are four cases on the summary calendar that are voted on as a group, and the cases are 18 Properties LLC at 255 18th Street in Brooklyn. Docket number is LS0237. Macy Pigman, 86 East 10th Street in Manhattan. Docket number TA0246. Richard Keene, 262 to 272 Mott Street in Manhattan. Docket number TM0096. And finally, Stephanie Fox at 783 Broadway in New York. Docket number TR1344. Does anyone have any comments or questions on these cases? Or comments on these cases?
Yes. On case number 4, 86 East 10th Street, this is a situation where a tenant moved into the building recently, paying very significant rent, to discover that there was no heat in the unit, and despite the owner, at the time the tenant moved in, which happened to be in autumn, say, oh yeah, we're going to get this fixed right away. It was never fixed. The temperature in the unit hovered around the 40s or 50s. Finally, the tenant's attorney withdrew the application and is deemed withdrawn without prejudice. This is a registered IMD building with 3 units in it at 86 East 10th Street. And the staff informed me that the board issued a narrative statement for the work in March of 2008. But it doesn't appear the owner ever pulled a permit. They did pull a permit for sprinkler work. Apparently there's been a fire in the building at some point in time. The Loft Board inspected it in January this year and issued violations for heat and gas on the bonds. So in the private session, I asked the staff a number of questions with regard to, here you've got a building in a very expensive neighborhood in New York, East 10th, 86 East 10th, where the owner hasn't done anything in the past 10 years to legalize the unit. Presumably, the reason there's a new tenant in there paying a high rent is because this unit got, the sale of rights was sold some time ago from a prior tenant. And what can the board do to move a building like this along? And some of the pictures, there's a picture of an electric heater, the cord from which goes out one window, out to the outside of the building, and back in another window to the place where it can be plugged in. And I would encourage the board not only to look into further violations, but I think this is a case where the board should use its power to seek specific performance to compel this owner to utilize this building. I think it's shameful that somebody can allow these conditions to exist, sucker some person who, in the correspondence that Ms. Pigman submitted, it's clear she was coming from out of town and didn't quite understand how cutthroat certain owners will be in promising that they're going to get things like heat fixed. Don't worry about it. And I think this is just a poster child case.
Anyone else?
If I could just say, we issued certification, we didn't issue a narrative statement, so the narrative statement comes from the owner. We are looking into what kind of enforcement action we can take not only on this building, but on other buildings that are in a similar situation. It is something that we want to think about and move forward with. What form that will take, we have not worked out yet. We are looking.
Okay, I would ask that perhaps you can give us an update next month on that?
Sure.
Specifically on this building?
Anyone else? Thank you. The motion then to accept these cases. Mr. Fernandez, Mr. Carver, second. Mr. Rivera.
Mr. Carver.
Yes.
Mr. Bauer.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Schaefer.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 1 absent.
Thank you, Mr. Rivera. There are 6 cases on the master calendar, including 3 removal cases. And the first case is, how do you say that, 7 Lindback and Graham Mosley at 736 Broadway in Manhattan, docket number TR 1172. Mr. Bauer, please present this case.
This tenant application, coverage application, seeks Article 7C coverage for the 9th and 10th floors of the building pursuant to MDL 281.5. In 1982, the then owner of the building registered the building as an IMD containing 7 IMD units pursuant to MDL 281.1. Among the registered IMD units was the 10th floor. The 9th floor was not included in the registration. In order number 1884, the board found the 10th floor to be abandoned pursuant to 210F of the Loft Board's rules. The issue here is whether the 10th floor, which is an IMD unit pursuant to 281.1, is entitled to coverage and rent regulation under 281.5. The Loft Board and the courts have held that where a unit was found covered pursuant to 281.1 or 4 and was the subject of a deregulating event, the unit will not be subject to coverage or rent regulation pursuant to MDL 281.5. In the report, Judge Spooner recommended that the board deny the coverage claims for the 10th floor because the 10th floor is already an IMD unit pursuant to 281.1 and was previously found abandoned pursuant to 210F. Therefore, it is not subject to rent regulation under 281.5. Staff recommends that the board accept Judge Spooner's recommendation. Here, although the deregulation of the 10th floor involves an abandonment finding, not a sale of rights, the distinction has no consequence. Pursuant to 210F7 little I and little I choice of the Loft Board's rules, the legal effect of the board's determination of an abandonment is the same as that of a sale of rights. In a stipulation dated April 30th, 2015, the applicant of the 9th floor withdrew his coverage claims with prejudice. Staff recommends that the board deem the coverage claims for the 9th floor unit withdrawn with prejudice. Staff recommends that the board deny the coverage claims for the 10th floor unit.
Thank you, Mr. Babick. Does anyone have any comments or questions for Mr. Babick on this case? Is there a motion then to accept this case? Mr. Carver, second. Mr. Hernandez, thank you. Mr. Rivera.
Mr. Carver.
Yes.
Mr. Bauer.
No.
Mr. Hernandez.
Yes.
Mr. Delaney.
No.
Mr. Shafter.
Yes.
Chairperson Henson.
Yeah.
Vote in favor, 2 against, 1 absent.
Case. That motion is transferred.
Yes.
Okay, thank you. The second matter on the calendar case is tenants of 130 Palmetto Street. The address is 130 Palmetto Street in Brooklyn. Docket number is TR1174, and Mr. Babick Taylor will present this case.
This tenant application seeks Article 7C coverage for 3 units on the 3rd floor pursuant to MDL 2815 and protected occupant status. In the report, the oath judge recommended that the board grant coverage to the building pursuant to 2815 containing 3 units on the 3rd floor. The oath judge also recommended that the board grant protected occupant status to the tenants. After the report was issued, owner filed an application registering the building as an IMD and listed units 3SF, 3NF, and 3R as IMD units and tenants as protected occupants. The Loft Board issued an IMD number for the building on November 28, 2017. As more than 45 calendar days have passed since owner filed the registration application, owner may not seek decoverage of the building pursuant to Section 205B5 of the Loft Board's rules. Staff recommends that the board dismiss the coverage claim only to the extent that the coverage of protected occupant claims are moot.
Thank you, Mr. Babick. Does anyone have any comments in this case?
Yes. There was considerable discussion in the private session that preceded the public session based on my questioning the opening of the order that says the Loft Board rejects as moot the report and recommendation of the ALJ in this case. And the language in the conclusion has been modified to read, since the owner has registered the building and listed the protected occupants, the Loft Board rejects the report only to the extent that coverage.
Mr. This is the beginning.
I have it here.
It's the beginning.
Okay, let's just.
Well, then why don't you set it straight and then we'll go from there.
Okay, it's in the beginning, and the beginning sentence will be, since the owner has registered the building, the units, and the tenants as protected occupants, the New York City Loft Board rejects as moot the report and recommendation of Administrative Law Judge Kevin Casey dated June 15, 2016.
Right, I believe that's what was agreed upon.
I had it down in the conclusion
Yes.
since it's essentially the same sentence.
I got you. All right.
So to finish my comment, the report and recommendation of the oath judge Kevin Casey in this case is actually one that covers in some detail and provides additional clarity to the ongoing issues, light and air issues with regard to what constitutes a legal window and what isn't a legal window. And therefore, my concern with our using the terminology that we reject the report and recommendation is based on a concern that somewhere down the road, attorneys may try to read into the fact that we state we reject this report and recommendation, that we take issue with the analysis, which I believe is correct. And both sides had architects. There was considerable discussion on the 3 windows that were found to qualify, and from my vantage point, important. interpretation of how to apply the language in the zoning resolution to these particular issues. And I believe that the board staff does not take issue with that analysis. However, we are hidebound, it seems, by our own rule that says all we can do with a report is accept, modify, reject, or remand. And in this case, modifying doesn't make sense. Accepting, I'm advised, is inappropriate insofar as the landlord has registered the building. So therefore, the only verb that is available to us is rejects. So that was the reason that this was the subject of considerable discussion.
Thanks for clarifying. Is there any other comments on this? No. Do we then have a motion to accept this case? Mr. Hernandez. Any second? And Mr. Roberts.
Mr. Carver?
Yes.
Mr. Roberts?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 1 absent.
Thank you, Mr. Bear. The next case is Christine Sakis and Laura Adiba at 145 Grand Street in Manhattan, docket number TR 1239. Mr. Bobbitt would again present his case.
This tenant application seeks Article 7C coverage for the second and fourth floor units pursuant to 281.5 and protected occupant status. Owner did not file an answer and was held in default. In the report, the oath judge recommended that the board grant coverage to the building pursuant to 281.5 containing 3 IMD units, the second, third, and fourth floor units. The oath judge also recommended that the board grant protected occupant status to the tenant applicants. After the report was issued, owner filed an application registering the building as an IMD, the second, third, and fourth floor units as IMD units, and tenants as the protected occupants. The Loft Board issued an IMD number for the building on May 16, 2017. As more than 45 calendar days have passed since owner filed the registration application, owner may not seek the coverage of the building pursuant to 205B5 of the Loft Board's rules. Staff recommends that the board dismiss the coverage application only to the extent that the coverage and protected occupant claims are removed.
Do you have some same kind of correction for the
And
board?
since the owner has registered the building,
This is the, you're just correcting the first sentence.
First
sentence of the oath.
so since the owner has registered the building, the units, and tenants as protected occupants, the New York City Loft Board rejects as moot the report and recommendation dated.
Thank you, Mr. Bobbitt. Does anyone have any comments or questions?
The same concerns, I won't bother
Same
repeating.
as the previous order. Then do I have a motion then to accept this case? Mr. Barber. Do we have a second? Mr. Schachter.
Mr. Carver?
Yes.
Mr. Roberts?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 1 absent.
Thank you, Mr. Rivera. Next, we turn to the removal cases. There are 3 cases on 37 West Realty LLC at 323 to 325 West 37th Street in Manhattan. And the docket number is LE0680. The next is 15 Warren Street LLC at 15 Warren Street in Manhattan. Docket number LE0684. The next case is 26 West 20th Street Corp. At 26 West 20th Street in Manhattan, docket number LE0691. Does anyone have any comments on these cases? Thank you. Is there any motion then to accept, a motion to accept these cases? Mr. Carver, is there a second? Mr. Hernandez.
Mr. Carver?
Yes.
Mr. Roberts?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 1 absent.
Thank you, Mr. Rivera. We're going now to the Loft Board rules for discussion of... I'm sorry, Mr. Delaney.
No, I just wanted,
I apologize.
just those of us who are interested in effective use of time, those 12 cases took a total of 26 minutes.
Twice.
But not all, even not all of us were present for the prior meeting, so.
Can we make an effective use of 2 minutes so we can have a quick recess before we go into the Loft Board of Rules, right? We're back in session, and we're now returning to a discussion of rules, rulemaking. And Ms. Boston will begin the discussion. I think there has been some discussion about where we'll begin, but I think I want to just finish up with chapter 1 now. If we have time to go on, is that okay? We want to just do chapter 1, continue on. If he needs time the next time, we're just going to bullet order.
I have done some further reading of chapter 1, and I have a number of points, and I'm afraid it would take quite a bit of time. So my offer was to put them in writing
Okay, yeah.
and submit them to discussion.
Absolutely, but if there's anyone else who would want to say, I mean, we can still go back to that next time. We just want to continue with whatever is available now for chapter 1, and then we go to chapter 2. Is that all right then? But you can still do what you're doing, and next month, if we still need to go to chapter 1, we'll.
Okay.
Chuck, if there's an issue of substance that you think is relevant for all of us to hear, I guess now would be the time for us to hear that.
All right. That'd be fine.
Is that all right? Okay, very good. All right, Ms. Boston's going to lead this.
If you want to start at the start, you want to go over the typos and
No, I don't want to go over the typos. The typos you can just send.
the notices. Oh, those.
Yeah.
Oh, okay.
Substantive.
Thank you, though, because that's important.
I guess, I'm sorry, but my thought is that both for today and for next time, if Mr. Hernandez had sort of proposed something of this a while ago, which is that if we could separate out the sort of the stylistic items, and we could just have those sort of, if possible, in advance, written, and then that way we can focus more on the sort of the substantive legal issues. And I realize that's maybe an artificial separation at times, but.
Well, it's my general understanding that we're looking at being able to work till about 4 today, is that correct? And having spent a lot of time looking for the first time at chapter 2, I think it would be a much more effective use of time for me to submit my comments on chapter 1 in writing to then, because chapter 2, this is all new territory.
Okay, so absent what Mr. Delaney wants to submit in writing, would there be any other comments or discussion on chapter 1?
I have a quick question that's more than just.
Yeah, and I just, before you do that, I just want to address the stylistic thing. If sometimes, punctuations do make a difference in rulemaking, and it changes the meaning of things. If that is what that does, of course, we should mention that, just to clarify. Yes, Mr. Cohen.
Okay. On page 13, Elaine, you had changed the word occupants to units,
Yeah.
and I was just kind of wondering, can an application include a unit? I mean, is that on purpose to say units? Is it?
Well, the problem is that we don't necessarily know who the occupants are, so it's fine if you know who's in the unit, then you could certainly put in the person's name and the unit number, but if you don't, then you're mailing it to the unit. So we felt that units was a more inclusive term.
All right, yeah.
So, yeah, we had a question last month about the definition of family member and whether or not that conformed to other versions. So we did cross-reference it against, it's actually the definitions in the ETPA and from the Rent Stabilization Code.
On the definition of family.
Family member, yeah, and if you want the exact citations, I can read those to you. But that's where this comes from.
Right.
We changed the legalization process on page 6, sorry. We changed the definition of legalization process from achieving compliance with Article 7D, alternative building codes and provisions of the MDL. That was something that we carried over from a previous draft that belonged to Chapter 2, but the legalization process is actually procuring a certificate of occupancy for the residential portions of the building or the IMD units, so we changed that.
As long as you're on that particular definition, I think process means procuring. It might read more smoothly if it was legalization process means the process of procuring. See, that's the kind of thing I'm sparing you all.
I wanted to note that we did add additional information to the definition of narrative statement at your request, Mr. Delaney. I still have an open comment from Mr. Delaney on definition of crimelessly, and I do believe that this is substantive. You wanted to think about the last clause or whether the lease remains in effect.
Right, and I think that turns on what we do in Chapter 2.
So you want to leave that open until we...
Yeah.
Okay. I'll just make a note, so...
Yeah, because in essence, we'd be making policy in the definition, which...
Okay.
I do have one other question. In Chapter 2, there are a couple places where we have the term landlord.
Yeah, it should be owner consistently.
Okay, it becomes
We
owner.
were going to change everything to responsible party, but since we're not doing all of the rules over, I think
Right.
I've been trying to take out responsible party and put owner back in. So
Okay.
if it says landlord, it should say owner.
So we don't need a definition of landlord.
No, please feel free to tell me to change it. On page 9, on the bottom of page 9, the board had approved last month of adding a section 1-15D. Any person who files or causes to be filed a document with the Loft Board that contains a material false statement will be subject to a penalty, but we didn't actually add a penalty. So I want to add a penalty, so that will be a change in Chapter 2, 2-11.1, or 2-11. So I just wanted to make you aware of that I'm going to include that next time. And I'm recommending a $5,000 penalty because that's what the charge is, the penalty that's in the building's penalty schedule has a $5,000 penalty. And then...
And it's currently what then? Oh, no, there's not.
Well, there isn't a fine for that. There is a fine for filing a false statement in a monthly report. So we can actually change that to just be filing a material false statement at any time, and it would be $5,000. We should also, as long as we're talking about penalties, add a penalty for violation of the Loft Board order, which we don't actually have in the penalty schedule. And I would propose that that would be the same $5,000. But that's not in front of you now, but just so you'll know that it's coming. We had the issue about foil that we were going to come back to when we talked about rules. So, request for inspection and copies of records should be addressed to, yeah, okay, so we should definitely change that. This is page 10. So it sets out the procedure for making a FOIL request. We should incorporate the open records order into that. So I will do that and bring that back to you next month.
And this will be with some kind of track changes?
Yes.
Just going back to the notion of a penalty for violation of the Loft Board order, would that be the case where we ordered you to register within 30 days, that you better
Yes.
do it?
Yes.
Okay.
That'll be in addition to the penalty for not registering.
Right.
And I just wanted to note that I changed the settlement rule back on page 20. to change it back to the way it was before, so at the board's request. And then we had an open item at the bottom of that page, 131E, where it said a proposed order shall not be part of the record of the case. So I think, Mr. Lulini, you had wanted to think about that. I don't really see how it can be part of the record, because we have another rule that talks about when a record closes for a case, and the record always closes prior to a proposed order.
Okay, I'll think about it.
Still thinking?
Still here.
Okay, that's all I got on chapter 1.
I'm sorry, there was so much good stuff in chapter 2. I just,
So here we go, we've got 25 minutes. All right, so starting on page 23, this is in rule format. So remember, the stuff that's in the brackets is deleted, and the stuff that's underlined is added, and the stuff that's neither of those is there already. So the first section is an amendment to section 201A of Title 29. So this is the section that sets forth the code compliance deadlines under each of the different iterations of the Loft law, and for whatever reason, when the 2015 amendments were passed, the board never actually did a rule. So this section just incorporates the code compliance deadlines that are in 281.5 for the 2015 amendments of the Loft law. So that's this section. So that's why it's all new. Anybody have any questions? Okay, yes.
yeah, no, do we need the language after, in the first line, as a result of the 2015 amendments to the Loft law?
The others are all worded that way, so yes, I think we do.
So we're following
Yeah,
our prior clunky language.
yes. If we were changing the whole thing, we might think differently, but I think we should be consistent.
Where are you at? Where is that piece? I'm sorry, I missed it. So that's not in our statement basis of purpose, is that what we did?
Well, the statement of basis and purpose talks about adding the code compliance deadlines. I don't remember exactly what I wrote. Add code, yes, it is in the statement of basis and purpose. It's the first bullet point on the bottom of page 2. The proposed amendments to chapter 2 will. It's the first bullet point.
So do you think it's necessary to put it there again?
Well, it's, I'm following the format of what was there before. I think it'll be clearer if we stick to the same format. If I had an opportunity to change it all, I would, but we're not doing that, so I think we should be consistent.
Okay, in little 1, I think it's found out alteration application within 9 months of.
Yes.
Similarly, in 2, second line, permit within 12 months of the initial coverage application or within 12 months of
Issuance
issuance
of an IMD.
and IMD number.
Yeah.
You've got another and for and
Yeah, I do that a
in
lot.
4.
Okay. And IMD number, okay. Anything else? Okay, the
3,
next.
after permit, you have both the period and the colon, and the semicolon, and the small a.
Okay. So the period should go. It should be a semicolon.
Well, it should be a comma.
Okay, I'll make it a comma. You want them all to be
So
commas?
this is what we talked about, right? So this doesn't,
Okay, I'll make them all commas.
Sometimes a comma makes
I know.
sense.
I know. Okay, section 201D2B of Title 29. So this is the narrative statement. So in all of our discussions with various parties, there were some some suggestions to changing the narrative statement process to help everybody know what's going on. So we want to make the, I'm sorry. So if the owner knows of an email address for a tenant, we're asking the owner to send a copy of the plans to the tenant. One of the things that I myself have experienced is when I look at a narrative statement, usually the first line of a narrative statement is, this narrative statement is to be read in conjunction with whatever the plans are. And if I don't have the plans in front of me, it's very, very difficult to know what's going on. So at least some sort of a floor plan. So in the past, it was very expensive for owners to have to replicate plans. Now, everything's filed for the most part electronically, so it seems to make sense to give the tenants the plans as well as the narrative statement if they can do that electronically. Obviously, the tenants could still get copies if they want to pay for hard copies. So that was one of the proposed reforms.
I believe, if I may, and if you think this is not a good time, that's okay too, but I just would like to tell the board that the narrative statement process is the nuts and bolts of the law board. Even though we don't deal with that process much, this is what the owners and the tenants are doing here. I know it involves an enormous amount of your resources, and it's the source of complaints from the owners far and wide. This is where they have problems with the board. And the fact that we're looking at it and making it better is great, and the fact that we're considering changes to it is positive, but I have to tell you that the owners are very upset that it's really not making the process faster with proposals. And I have some notes on ways that I think the process might be made better. I made copies. I don't know if it's something that you want to take with you, and then when we meet next time, because I know we're near the end, we could all look at them and think about whether or not those ideas are good, and if they are good, then we may want to play around some more with the language. But just as a global matter, I just want to impress on the board how important this might be the most important thing that we're actually working on to get the process moving faster, especially since I believe that to meet the code compliance deadlines, I believe we need to get through this process.
Yes.
Yeah, so this is critical, and
Yes.
since rent could depend on meeting those deadlines, and rent is needed to do the work in many cases. The issues that I'm going to raise with you are something that I really hope everyone will pay close attention to. So those are just my general comments about narrative.
So just, if I could just say,
Yeah.
I certainly am more than happy to consider anything that anybody wants to propose. It's ultimately the board's decision on anything.
Of course.
But I will say that we did meet with tenant representatives twice and asked them for proposals and didn't really get anything substantive, so.
Well, you said you met with tenants twice.
No, I'm sorry, owners twice.
Okay. Well,
Owners, we met with an owners organization on two separate occasions, and we repeatedly said, and one of which we actually discussed this proposal about the electronic plans and all of that, and we did ask them for additional proposals if they had any, and we hadn't actually gotten any.
okay. Well,
So-
I have them.
Okay.
And, would you like me to hand them out to you on our way out? I mean, you tell me how.
I mean, I think if you could send them to me electronically and you could circulate them
Okay,
to
yeah.
the board members, I think that would probably be the best thing.
Okay.
I would just like to state that, it's always a wonderful moment when the owners and tenants are in agreement about anything. And there's certainly a lot of dissatisfaction with the narrative statement process from the tenant's vantage point as well. And I also am in 100% agreement with Mr. Carver that the narrative statement conference is something that is one of the most important aspects of what the Loft Board does, and it's something that doesn't really engage the board members that frequently, and maybe it would be, in addition to plowing through language line by line, maybe it would be good to devote 15, 20 minutes to the discussion of more generally about what some of the issues and problems are, rather than try to see particularly for the other board members, rather than just, in addition to looking at specific language. And certainly, my building went through a narrative statement conference many years ago. It was typical of the buildings of those days in that there were 3 units. A big building was 12 or 13 units. Now we have buildings with 40, 50, 60 or more units, so that there are a host of issues that come up. And obviously, there's a balancing act between fast tracking, code compliance deadlines, but I'm certainly in agreement that it's a very important process.
So I'm not 100% sure what you're asking. Do you want an overview of how it works, or some of the issues that we see, or?
At some point during the rulemaking process around the narrative statement, I think that would be helpful. I mean, I'll give you an example. One of the things I've heard from tenants for many years, going back prior to the current staffological status of the Loft Board, is a feeling that there's been ex parte communications between Loft Board staff and owners. There's a whole question of what and how these narrative statement conferences should be memorialized, should they be recorded. There are a host of issues, which I plan to raise today, however we go about it, but maybe, and I'd certainly be interested to hear what the owner's concerns are.
Helene, if you're offering a 5-minute overview of what really happens, I would like to hear it.
Okay.
Right now?
I think it would help inform.
Sure.
But if it's not a good idea, that's okay.
No, it's fine. The owner files their alteration application and files a narrative statement and reschedule a conference, and sometimes they can be scheduled because you have lots of people involved, so lots of tenants. But even if you don't have a lot of tenants, you usually have architects on both sides, you have attorneys on both sides, so you're talking about lots of people. So that's one issue that slows the process down. At the conference, the owner, and it is very much a mediation, okay? It's much more in line with mediation than it is. It's not really meant to be an adversarial process. The idea is to get people talking. So you can't have an ex parte conversation at a narrative statement, pertaining to a narrative statement, because there's no pending application. But basically, we sit down, and we say, we introduce ourselves, we have a statement that we make to the tenants, everybody introduces themselves around the room, who they are, and we have a statement that we make to the tenants that says, this is your opportunity to look at the plans, to comment on the plans, to ask questions, and we try and facilitate the discussion, and the owner presents their plans. A lot of times, the tenant's architect has already seen the plans and has submitted comments.
I'm sorry, can you just maybe encourage? Thank you.
What's that?
It's noisy out in the hall.
Oh, okay.
I'm trying to listen to you now.
Okay. All right, so a lot of times the owner's architect has actually already seen the plans and has submitted comments in advance, which is always great. And basically, we'll start with
The tenant's architect.
the tenant's architect,
Yeah.
the tenant's architect. we'll start with the general comments about the building as a whole. You need a sprinkler here, you need this, you need that, and then work down to the individual units. So each tenant will come to the front of the table. The architect spreads out the plan. Hopefully they have big enough plans. Sometimes I'm sitting there with my, what is it called? Magnifying glass, thank you, senior moment. I'm sitting there with my magnifying glass trying to read the plans, and they talk about the plans. Sometimes it's, very cordial and everybody's fine. Sometimes it's not so cordial. A lot of times the tenants will want things that the owner will say, well, DOB issued us an objection. And one of the things that we're talking about in the rules, in changing this rule, is to have those objection sheets available to the tenants to examine them, because the DOB plan examination is very much a DOB owner thing, and it's very difficult for the tenants to necessarily get a handle on what the objection is. So that's one of the proposals that we're making. And basically, we go through everything. If we can't finish in one conference, then we'll schedule another one until we work it out. If we can't work it out, then we have the alternate plan process, which is a whole different thing. But that's basically how it works. So the idea is to try and get everybody on the same page and to agree as to how a unit should be legalized. And if people are reasonable, it usually works out, but not always.
So when you say that there's a DOB plan objection, that's an objection to the owner's architectural plans?
Correct. So the owner is proposing, the owner is proposing to leave a step. There's a step down from the living room to the dining room, and that's like not ADA compliant. A lot of it centers around ADA compliance. So the owner will come back and say to the tenant, I know you really like having the sunken dining room, but we got an objection from the DOB. And a lot of times the tenants or architects will come forward with ideas to solve those problems. And there have been many times where I've heard the owner's architect say, yes, we like so-and-so's plan, we're going to adopt that, but not always. So that's pretty much how it works.
When you say to go over everything, are they going over, is there a list of agenda items that have been identified by the tenants as well as the owners, or is there an internal list of objections that have been identified? Not DOB ones.
So usually if the tenant's architect has seen the plans and has done a list, then they'll start working off that list. If not, then the owner will start, usually they'll just say, okay, here are the plans. We will say, does anybody have any objections about the common areas? You understand what's going to happen, and then move to the individual units.
I just have, just because I don't understand the process
Yeah.
fully myself, but how is DOB involved at this stage?
So the owner has filed their alteration plan with the Department of Buildings, and you should probably do no better, but.
Okay, so the question is, how is DOB involved at
This stage, because I'm hearing that there's already an objection from DOB
Well,
possibly.
They're file plans for approval, right? And
I'm sorry, this is without any interaction with the tenant. This is just the owner on his own. Okay.
Well, they have done a survey of the property, and they have to document the as-built conditions.
Okay.
Tenants have given access.
Yes.
Okay.
right, and they file plans, and buildings have sat with their architects or engineers have sat with the plan examiner, and plan examiner have gone over these plans, and if there are objections, those are brought back for discussion.
In some of these cases, I think the idea is that they're filing the plans because they want to see what is feasible or not. And without having, because there's no real consultation prior to plan review. And so the only way where an owner will have an opportunity of being able to understand whether something is feasible is by pushing it through the plan review process. That gives the plan examiner an opportunity to say yay or nay. And the nays are generally the objections. And that's, I'm assuming that's why then they hit to the point.
You're saying plans are a wish list.
Yeah, the plan exam is basically a wish list, which then I guess presents the opportunity of these narrative sessions to go to reconcile, I guess, between the tenant and the owner.
Right.
Because they're going to go back to plan review if they want.
They have to.
Yeah.
when you were discussing last month or the month before about training DOD planners on this,
Yes,
is that at this stage?
Before.
before.
And
Yes.
it's basically, when you say, I mean, these guys, planning examiners, presumably know what they're doing.
Oh, yes,
I'm just saying, when we talk about training them, we're talking about, kind of re-educating them on the loft law and so forth, the procedures of the loft board, so that they are kind of all in one sheet of music, so to speak.
Has that happened? Have you been speaking with, I mean,
Yes,
that's
Yes.
ongoing.
That's ongoing.
And what would be the unique aspects? I mean, the idea is that ultimately DOB is reviewing to ascertain whether it's appropriate health, safety.
Interpretations, I guess.
Well, also, I mean, there are, loft buildings are kind of unique. They present different problems than just a regular residential building. For example, one problem that surfaced recently, which DOB is still deciding how to deal with, is depth of units, right? So there's a limit as to how deep a residential unit can be, like how far from the door can the bedroom be. But if you have a building that's 50 feet long and all of the units are the entire floor, what do you do with that? And maybe you need to carve out some exceptions for loft buildings, and these are issues that DOB is working through.
So non-conforming.
Correct.
The other thing that is so important and unique about this process is that, the loft law basically said, Mr. Owner, you've got to bring this building up to code compliance and make these units compliant, for the most part, with the tenants in place. So therefore, in my building, one of the things that had to be done is that there was substantial PVC plumbing that had to be replaced with copper. Why we need copper over PVC is a discussion for another day and another time. It's legal under the state code, but not the New York City code. Is that the plumbers union, or is it a health and safety issue? Forget about all that. But, so to be able to discuss with the loft board being kind of a referee, well, how are you going to do this? Well, we'll start on this floor. Now, will you all in the other floors let Chuck use your bathroom for the 3 days we estimate it will take? Then we plan to take a week's break and come back and do the 4th floor. So, and we don't think each floor will take more than 2 or 3 days. There's a lot of that kind of agreement on how to stage this. Now, how much that's relevant when you get to a building with 50 units, or how much that's feasible when you get to a building with 50 units, I'm not in a position to really assess that. But it's rare. I mean, most of the time, the renovations are done, the tenant is not living there. They're done before the C of O is granted, before people move in, or you do a gut rehab of a building and create new units. So doing all this work with tenants in place is very unusual, and Helene's right, that normally the narrative statement process provides a window for the tenants to see what the owner intends and to question him as exactly how he or she planned to go about it.
So that's basically how it works. And we're done.
Okay, we're done, but I just want to ask you one quick question about this, page 24,
Yeah.
email, fax.
Oh, yeah, so we didn't get that far, but yeah, in terms of serving the narrative statement, I mean, right now, everything's still on paper and has to be served by regular mail, so we want to bring us into this century and allow for email service, fax service, et cetera, and get rid of the paper as much as we can.
I just had a question about the word knows. So if the owner knows, I mean, I'm not, no lawyer here, but I'm not sure if there is a definition of knows, but I just wondered if it could be replaced by something like if the owner is provided an email address for the family, address for the occupant, like that. I would prefer, just to know it. I mean, the owner could say, well,
Maybe they know.
someone told me that this is it. But it wasn't really what was provided to them. Something like that could be problematic, where somebody makes something, looks on the internet and finds somebody's email address and just sends it out to some. And there's so many multiple email addresses that people use. So preferably if the occupant would provide that, or have been provided by the occupant. And of course, the same as fax, I'm not sure we do faxes anymore.
We are, well, we do because we have some rules that say people can fax, but.
Well, Ronaldo, this is a global issue, not just for this section.
Yeah.
Yeah. I mean, just to know it, just to say if someone knows it, I think it's more,
I mean, remember that these people are rentals and tenants, right? And, you know, and tenants, so they have some sort of a relationship. But yes, I agree with you. It's not the word.
it looks like everybody's looking at me. That means this concludes our April 19th, 2018 Loft Board meeting. Our next public meeting will be held at 22 Reed Street right here on the first floor on May 10th, 2018 at 2 p.m. And I just want to reiterate that that meeting is solely rulemaking.
The first May, there are two May meetings.
There are two main
May 10th. The next meeting is May 10th, and that's a rulemaking meeting. Thank you for your